This lecture examines Tijmen Wisman's chapter, The Problem of Invisible Power in Data Protection Law. Wisman asks a deceptively simple question. When public authorities use data to classify, score, and act upon people, does the GDPR give those people a meaningful way to see and contest the power exercised over them? His answer is quite unsettling. The regulation offers formal rights, but those rights often fail at the point where administrative power becomes least visible and most consequential. The chapter starts from a basic transformation in government. Computerized administration allows public bodies to collect dossiers, combine records across agencies, and convert those records into labels that influence access to benefits, services, opportunities. Wisman notes that UK researchers identified 53 local councils using predictive analytics to score individuals without giving those individuals a practical way to know the score, understand how it arose, or challenge it. The chapter therefore shifts attention from data processing as an abstract compliance event and toward the legal position of the citizen who becomes the object of administrative classification. Wisman defines invisible power through two linked failures. The first is opacity. A person may not know that data has been collected, shared, enriched, or mined, still less that a public authority has used the resulting profile to shape a decision. The second is indefensibility. Even when a person experiences an adverse consequence, that person may have no workable route to inspect the presumed facts, labels, or risk indicators behind it. Opacity hides the exercise of power. Indefensibility prevents the subject from answering it. Together, they produce an administrative system in which a person can be governed by an informational case that the person cannot see. The historical argument is central. Early debates about computerized records in the United States and Europe recognized the due process problem. Hidden records could alter a person's legal position without notice, participation, or an effective remedy. Yet the emerging field of data protection translated that problem mainly into the language of privacy. Wisman argues that this translation carried a cost. Privacy, particularly under Article 8 of the European Convention, is a qualified right. Due process, fair trial, effective remedy, and good administration impose a different constitutional discipline. By framing invisible administration principally as privacy interference, data protection law made a problem of procedural justice more amenable to exceptions, balancing, and legislative authorization. On paper, the GDPR appears to answer the problem through three sets of safeguards. First, Articles 13 to 15 impose information and access duties. Secondly, Article 22 protects people against certain solely automated decisions and supplies safeguards such as human intervention, the opportunity to express a view, and the ability to contest a decision. Thirdly, Article 23 subjects restrictions on those rights to legality, necessity, proportionality, and respect for the essence of fundamental rights. The SCHUFA judgment gives some cause for optimism because the court interpreted the concept of a decision broadly and treated the safeguards around automated decision-making as integral to effective protection. Wisman nevertheless identifies several structural leaks. Article 14 allows information to be withheld where disclosure would make the processing impossible or seriously impair its objectives. Article 22 depends upon contestable thresholds, including whether a decision is solely automated and whether it produces legal or similarly significant effects. Public authorities can organize workflows so that human formally remains in the loop, or so that a label sits upstream from the eventual decision. Decisions authorized by law also expose the safeguards to legislative discretion. Article 23 then permits restrictions across a wide range of rights. The result is a troubling possibility. An administrative system may satisfy a formal legal basis while remaining opaque and practically indefensible. The first case study is SyRI, the Dutch System Risk Indication Program. SyRI linked records held by several public bodies, applied a secret risk model, and produced risk reports identifying people considered worthy of fraud investigation. Those affected received little meaningful notice and could not inspect the indicators or model. A Dutch court struck the scheme down in 2020 and stressed that secrecy prevented people from defending themselves. Wisman nevertheless reads the judgment cautiously. By suggesting that additional safeguards might compensate for the lack of insight, the court left open the possibility that legislators could preserve the underlying exercise of invisible power. A privacy victory did not necessarily create a categorical constitutional bar against secret administrative scoring. The second case study concerns the Dutch tax service fraud signal facility, or FSV. The database contained internal and external fraud signals and stored special category data about thousands of people. Operational labels such as 1 by 1 and 0/GS, meaning intent or gross negligence, transformed suspicion into practical consequences. People lost access to payment arrangements, faced large debts, and in some cases experienced poverty, severe stress, and risk to family life. Wisman emphasizes how official analyses reduce this institutional injustice to familiar data protection categories such as lawfulness, accuracy, purpose limitation, and storage. That framing could identify bad data management, yet it struggled to name the deeper wrong. A shadow administration had punished people through classifications they could neither see nor contest. Wisman reaches three conclusions. First, privacy framing does not adequately capture the due process stakes of invisible administrative power. Secondly, the GDPR combines clearer transparency rules with broad exceptions and ambiguous thresholds that permit circumvention. And thirdly, courts, journalists, and civil society can expose particular systems, but structural protection cannot depend upon those actors discovering each hidden practice after harm has occurred. The chapter therefore asks us to move from a narrow concern with whether data is correct and lawfully processed towards a constitutional concern with whether state power is visible, reasoned, and contestable. The core takeaway is that data protection law should not treat transparency and contestability as optional features that disappear whenever administrative objectives becomes difficult. Opacity and indefensibility describe failures of constitutional government, not merely failures of information management. In the next lecture, we turn from hidden administrative power to a different accountability mechanism. My former colleague, Professor Bart Shermer's assessment of whether data protection impact assessments under Article 35 actually work in practice. The book and the full series are linked on the screen.